Yeah, I'm
live.
waiting for him to start. I'm waiting for
We're
him
live.
to start the show.
You're live. You're live.
Am I live?
Yes.
Okay, well, there we go. I see I'm live now. Good afternoon. Hey, nice to see you, Mark, and welcome the folks to episode number 39 of At Your Service with Haber and Martinez. You'll note there is no Martinez today. He's got caught up in court, and Mark, what is it, Lawyer Mark on TikTok, right, has graciously agreed to come on and fill. Go ahead.
The only reason I'm on here is because we're not talking about the Ed Martinez origin story today, but for any other topic, I will come on.
Excellent.
Have you done that? Have you
and in
done
honor
that yet?
of Martinez, who's not. No, we're avoiding that one. That's like with it's another show for another day. But I am wearing a guayabera in his honor, so
Okay.
We have a little bit of a Cuban flair. Although I feel like I should be taking an order in a Cuban restaurant wearing this white guayabera. But that said, let's get into the meat and potatoes of what it is that we're going to talk about today. I've labeled the show episode number 39, The Anatomy of a Domestic Violence DV Case in Criminal Court. And basically how this came to be is Mark and I were talking about a trial that we were scheduled to have last week in domestic violence court, and some very interesting curveballs happened during the course of that case. And because of those things, they're unique. We've been practicing law for 30 years each. And when you do 30 years of litigation, you don't have too many original concepts that come across. But there were things that happened here that were unique and interesting. And so we thought we might share them in terms of going through what happened in this particular case from start to finish, and how these little curveballs seem to pop themselves up, and then translating that into some form of pro tips so that you guys, the folks, can understand stuff that your lawyers should be looking at and that you should be thinking about as clients in order to help yourselves and to help your lawyers to help you, right? Am I delayed? Are you hearing me, Mark?
I'm hearing you. Was that a question?
Oh, no, I was just throwing it out there. Just, kind of, yeah.
It's delayed, but I think we ought to go over the three things that we need to look at when you get a case and you're prepping it for trial. You ready for these three? The first one is details.
Yep.
The second one is details, and the third one is details, because in this particular case that we're breaking down, that you're going to talk about, Mike, to your viewers, if we didn't go through again, and then the night before or 2 nights before the actual trial was set, and we didn't keep going through those, the discovery from this date, we would have missed some very, very serious issues that were like picking up with a tweezers. You wouldn't have seen it without a magnifying glass. And that really that made the difference in this case for our client. So experience and due diligence in investigating a case that a client brings to you, you have to just sit down and go through literally every word on every report, every date, every place, every time, and see if it matches up like a puzzle, which is what we did.
So let me run on that details note and just say I'm going to plagiarize Jack Reacher, which is one of Ed's favorite things to do, and say details matter. If anybody saw the most recent Jack Reacher series on Amazon, that was the running theme of the show. Details matter, and they really do. So in this case, as it turns out, there were some details that Mark and I didn't become aware of until very late in the case. And these are predictable, yet unpredictable. In other words, you can't predict a lot of things that are going to happen, but you can predict that things that you don't predict to happen will happen, right? So I kind of put in the promo of today's show, the first rule of criminal court, kind of like the first rule of Fight Club. So the first rule is, while it exists, we don't really talk about it, but anything is possible. What is probable is another story. Expect the unexpected. And no matter what, your odds at a favorable outcome are going to exponentially increase with the assistance of a skilled and experienced criminal defense lawyer. So that's really kind of like 4 rules in one, but that's really the overarching principle in any criminal case. So let's just talk about this DV case. And I'm going to give you guys, I'm going to read you the A form. Obviously, I'm not going to give you the specifics of the client's particular case, but this is a real world case. The defendant is the mother of the victim's 3-year-old child. The witness is the mother of the victim's older child. On X date, the victim visited the witness at her residence. The defendant showed up uninvited. The defendant confronted the victim, at which time the defendant became irate, striking the victim several times in the face with a closed fist. The victim did not sustain any injuries. Then it skips to today's date, which is a full 5-6 weeks after that. Defendant was brought to the blank police department by crime suppression team units, was placed in a recorded interview room. Post Miranda per card, defendant agreed to speak with this reporter. Defendant denied going to the witness's residence. Defendant denied striking the victim. Defendant was arrested and transported for misdemeanor domestic battery. So that's the A form. It's very plain and simple. The A form basically tells us that 6 weeks prior to the defendant's arrest, in this case, the defendant is a female, prior to the defendant's arrest, an alleged incident occurred. On that date and time, the date and time of the incident, the police were called. There was a 911 call made. The police showed up. According to the arrest report, the responding police officer who did arrive at the scene was wearing a body camera. So that individual, that officer, interviews the complaining witness, which is the victim, the baby father, and the alleged witness, who is baby mama number 1. And all of that's allegedly to be recorded on the body cam. Irrespective of that, the report is written, and you would assume that at some point down the road, when we are able to get a hold of the body cam footage, we'll be able to review it and then compare notes. And as Mark said, details. Does what we view and hear in the body cam align with what the officer wrote in the police report? And if not, then what are the distinctions? How significant are they? Can we use them? Do they rise to the level of our being able to use them for a motion to dismiss? Or are they simply going to be possible things for cross-examination and impeachment of witnesses? So when this case happens, it's about 6 weeks later, and normally that's not the case. Usually in these cases, the arrested individual, the defendant, is arrested on scene. But in this case, again, it was about 6 weeks later. So what happens during that 6-week period? Well, nothing. Our client lives her life. She doesn't bother calling us because the police haven't been in touch with her. As far as she knows, there's no issue. We don't hear from her until she ultimately gets arrested down the pike. When she does get arrested, we are now brought into the fold. And again, we know through our practice and experience that the first thing we have to deal with is bond. This person is in jail. In any domestic violence case here in the state of Florida, if you're arrested, you must be held until you are taken in front of a judge. You cannot post bond until after a judge has seen you and given you what's called a no contact or a stay away order. It's a mandatory provision in any domestic violence case, regardless of felony, misdemeanor, weapons, repeat, makes no difference. If DV is stamped on the file, then the judge must give you that stay away order. So you're not allowed to post bond until that point. So fast forward, we get our client bonded out, and we start to sit down, review the only document that we have available to us at that point, which is the police report that I just read you. That arrest report is a very bare-boned document. It does not contain all of the facts and circumstances of the case. It certainly does not contain all of the evidence in the case, but it is a statement of probable cause that the court can rely upon in its 4 corners to determine whether or not the burden has been met for this individual to be able to be bonded or have to be released on their own recognizance. So when we sit down with the client, what do we do? What does a good, responsible defense attorney do? How does that go, Mark?
Well, the way I conduct an interview is, and a lot of people, they'll look at me when I ask certain questions, like what's the relevance of that? And I tell them, don't worry about what the relevance is of it. I I'm putting together, I'm listening to what a future client is telling me, and I'm already putting together a possible defense from what they're telling me. Unless they're giving me a scenario where they are so absolutely guilty, dyed in the wool, we're constantly searching for a defense. Now, when I say absolutely guilty, I really don't know what that means, okay? Because, and Mike, you'll get to this in a minute, but the reason that this case that we're going to talk about today, it's very simple in what you just read. But a lot of the conditions that you just talked about, all that, that's a lot of, you know, that's a lot of technicality for a lot of people. But this everybody will get. In this case, the evidence were the two parties videotaping and audio taping each other. There was a video recording taken by the victim of the alleged defendant.
Right, but we don't know any of that at this point. We haven't been told any of that.
No, but I want your viewers to understand something, that when I'm talking to in an interview, I want to know that. I want to know, hey, have you ever recorded any of the other parties in this case? If you were taking video, did anybody else take video? I need to know that for the initial interview. In this case, our client did kind of left out a few details in the beginning.
Well, but
that was a late recording, though. It was a late recording.
Right, in her defense, we didn't know that there was a video. We didn't find out that there was a video of the incident until the night before trial when the state tendered it to us, and we'll get there later. And as for the audio recording, that didn't happen until about a week before trial. Didn't exist. Right.
The client knew that the victim had a phone in her face, so she knew she was being recorded, and she just never brought it up.
Maybe. Or maybe the video was from another separate incident because it was never authenticated.
I want my client to tell me if somebody is putting up a phone on them while they're committing an alleged crime, and tell me it may exist, Mark. Okay, that's all I'm saying.
Yeah, no, I think what Mark is trying to get across, and the point that we want to give you is, during that initial consultation, it's really important for you to fully, honestly, without holding back or disclosing or sugarcoating or amending or exaggerating, just be honest and truthful and complete with your lawyer, because our job is to help you. And the conversation is privileged. And even if you wind up firing us or we wind up withdrawing from your case, we're still bound by confidentiality and we cannot reveal anything that you told us. But we also cannot give you really good, competent, custom-tailored service without being fully versed in the facts and circumstances, because we're not just looking at your case from the prism of your eyes, we're also looking at it from the prism of our individual 30 years of experience in dealing with these types of cases. So something that may be trivial or unimportant to you could be very pivotal to us. In fact, it could be a game changer, as turned out in this case. Although, again, when we initially debriefed the client, these facts were not there. But there was one fact that the client did fail to give us, which was exceedingly important. And in this particular case, from DV purposes, but the principle could apply to any case. So in this case, one of the things that our client did not tell us, and we did not find out until about, very late in the case, but the reason that we found it was because of what Mark repeated as the first three rules: details, paying attention to detail, or as Reacher says, details matter, right? In going through the police reports, we found a little blurb on a checkbox on a report that said that there were prior incidents of violence. Now, we knew that our client and the victim, alleged victim, had prior incidents between them of undocumented violence. But what we did not know, and what that prompted us to discover, was that our client had petitioned for and secured a permanent injunction for domestic violence against her baby father, against that victim, 3 years or 4 years earlier. And that injunction was still in effect at the time of this incident. We didn't know that. Partially, mostly, primarily, because our client never told us. But there is a secondary reason. And that is, everybody's got their path, right? You've got your tasks that you do. And so our job is lawyering. And a lot of people, going back to the issue of bond, a lot of people, the first thing they think when they get arrested is, call my lawyer to bond me out. No, lawyers don't bond people out. Now, if you have to appear in front of a judge, if you have to have an initial appearance and a bond review, yes, you need a lawyer. But if you're sitting in a jail cell and you're bondable, a lawyer can't bond you out unless he or she happens to be going to deposit his or her own cash with the clerk of the court. The person who bonds you out is a surety. And so to the same extent, when it comes to investigating criminal cases, while we do as much as we can, we employ private investigators to assist us because they are trained to do this type of work. So one of the things that we did not know was that this restraining order existed. And as it turns out, that became a very pivotal matter for us in our case, as we discovered really in the moment of trial when we were in the courtroom litigating pretrial motions in limine. But again, we'll get there in a few minutes. So let me go to the next police report, because now our client gets arrested. She gets bonded out of jail. We enter an appearance. We have debriefed her. We start open our file. We enter our appearances with the court, and we demand discovery. Discovery is the process where we say to the state, look it, give us everything that you have. Everything that you have. You're obligated by law to give it to us. We are asking for it. We need it in order to prepare. Well, why do we want the discovery? We want to see everything. Like, for example, we know from the A form that this individual, that the responding officer was wearing a body cam. We'd like to see and hear for ourselves, how did this guy appear? What was his demeanor? How was his behavior? What were his exact words? How did he describe things? Did the officer get it right when they transcribed their police report? Did they miss any details? What did the alleged witness say? Plus, we can see the entire scene in real time. So we want that stuff, and we only get it if we ask for it through discovery, or if we go through the time-consuming and painstaking process of public records requests under Chapter 119. So the state's got 15 days to provide us with all this material, and now it starts trickling in. So what do we get? We get an offense incident report. What is an offense incident report? It's a report subsequent to the original arrest report, either authored by the same arresting officer who comes up with additional information, or by other officers who are involved in the case. In this instance, it's done by another officer, and that's the officer who actually wound up arresting our client after our client was brought in 6 or so weeks later. So let me read you what this report says. It goes back and details what happened during the initial arrest report. In other words, this secondary detective repeats basically what the original responding officer wrote, and then confirms BWC activated, meaning body worn was activated. Then this detective starts writing what she did. I was date and time. I was assigned to a domestic battery case. I spoke with the victim on the phone. He advised blah, blah, blah. I left a voicemail on the phone for the witness. The witness called me back at another date and time. The witness told me blah, blah, blah. By the way, even in here it says, the witness informed that her residence is equipped with a Ring camera system. However, the incident was not captured on Ring video. Then there's more follow-up, 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 and then ultimately we get to the point, which is about, 2 weeks later, where, quote, a probable cause to arrest flyer was created and disseminated. See attached document for further details. And then subsequent to that probable cause arrest flyer, our client was brought in, and this detective indicates that she's the one who spoke to her, and that our client agreed to speak after Miranda and indicated that she did not go to the residence and she did not strike anybody. So we now have that report. We also get the flyer. We get the probable cause flyer. We get the property receipt. We get our client's prior criminal history, her rap sheet, her priors. We get a list of witnesses that the government may or may not call in this case. We get a document, and by the way, and that's all they give us. So now we have all of this, and we get to review the case with a little more detail, right? Because we know more than just that 3-paragraph, 1-page arrest report that we initially had to work off of. But we still don't have a whole lot. So we've got those documents, and we've got the debrief of the client. So now we're missing material. And now we file a motion. We file what's called a motion to compel. And the motion to compel says to the court, look at Judge, the state gave us X, Y, and Z, but they have not yet given us A, B, and C. We're entitled to it. It exists, and we need it. Please give it to us. So in this case, what did we ask for that we were not given? Well, in virtually every domestic violence case, at least here in Dade County, there is a thing called a, quote, DV packet. And the DV packet has a checklist of items that the officer is supposed to ask the victim and the defendant, if the defendant is there. And it's got like that anatomy chart where they show where the injuries were, what was observed, what was the demeanor, what was the behavior. Well, let me just run down the list while I have it right in front of me. So clearly mark all that apply. And there's columns for both the victim and the subject, right? First is demeanor. Angry, apologetic, crying, fearful, hysterical, calm, irrational, nervous, threatening, other, explain. Then it goes to injuries. Complaining of pain, bruises, abrasions, minor cuts, lacerations, fractures, nothing visible or other, explain. Then it goes to medical treatment. None, refused, first aid, fire rescue, hospital, see doctor, will see doctor. Then it goes to alcohol use, drug use, is the person pregnant? Then it goes to the nature of the relationship, prior history of domestic violence, whether or not there are witnesses, injunctions. Well, this is where we find out, ultimately, because we don't have this document yet. It was not given to us in discovery. But we find out later about the injunction because of this document. So number one, we don't have this DV packet, and we know that it's routine. It should be there, so we move to compel it. Number two, we don't have the 911 call. And we want it. We want to hear it. We want to know who called 911, what did they say, and how did they say it? Again, does it comport with the body cam? Does it comport with any written statements or victim statements? Three, we haven't gotten the body cam footage. We want it. We need it. Four, what was the other thing that we were missing? There was something else we were missing. 911, body cam, DV packet, and there was something else. It'll come to me later. So we move to compel these items, and the court hears our motion to compel and grants it. It says, state, get those materials over to the defense ASAP. Subsequently, we get an email from the prosecutor, and the email from the prosecutor says, I'm including the DV packet. Oh, handwritten statements. That was the fourth thing. We wanted the handwritten statements, which are protocol in DV cases for the victim and any witnesses to handwrite, on top of being on body cam. Some agencies don't have body cam. Anyhow, the ASA sends us back an email that says, attached, please find the domestic violence report, the packet. We have that for you. However, the 911 call doesn't exist. It has been destroyed. Nobody requested it in a viable time period. We can no longer produce it. The body-worn camera footage does not exist. The police department has advised us that there was a malfunction with the equipment, and therefore there is no body cam footage, and no handwritten statements were taken from either the victim or the witness. So we start going through this DV report, and we notice a couple of things on it. First off, obviously, again, our client was not there, so there's nothing checked off in any of her columns. But when we look at this, what we see is the demeanor of the victim was, quote, angry and hysterical. The injuries of the victim, remember I gave you that whole list of possible injuries? Well, the only thing that's checked is none visible. And then, of course, he refused fire rescue. But what we find here is that, are there any injunctions in force? Yes. Verified? No. So the police officer didn't even bother to check and see any injunctions, because if the police officer had, what the police officer would have seen is that the person that he was there interviewing, the alleged victim, had an injunction and was not allowed to be within 500 feet of our client, period, paragraph. So that was a screw up by the cops, and something which Mark and I now knew that we could take advantage of in terms of showing how shoddy this police investigation is, because here's a cop who indicates that there actually is an injunction, yet he didn't even bother to verify it. And had he probably would have wound up arresting the victim, or at least have had to explain why he didn't arrest the victim, for violating that restraining order, which was in effect. So now we've got this piece of evidence, and we go to our client. We say, what's the deal with this? And we now find out for the first time the history of this injunction, which is for lack of a better term, a shit show in and of itself, right? 4 years earlier, she took out an injunction against him for acts of domestic violence that he committed against her. After he got served with her injunction, with the temporary restraining order, he went and filed an injunction against her, and he filed an injunction against her also on behalf of the minor child. So now all three of these injunctions get consolidated. They go in front of the same civil judge, and this knucklehead doesn't appear for his own hearing. So both of his petitions get dismissed. Our client, who is present, her petition gets granted. It's granted on a permanent basis and, quote, for an indefinite time period. In other words, the judge is leaving it open until the matter is brought back in front of the judge, if ever. And as a consequence of the injunction and in the injunction itself, our client is given 100% time sharing with the child. So now we have a complete discussion with the client about this, and our eyes become slightly more illuminated, right? How does that change our case, Mark?
Well, all right. That was a lot to swallow right there.
Yeah.
Okay, I'd like, first of all, when you tell people that the state has to give us what's called discovery, show us your cards, well, the same works for us, okay? If we have cards that don't incriminate our client, that we intend to possibly use a trial that could show our client is innocent, it's called exculpatory. Inculpatory means evidence that tends to show that you're guilty. Exculpatory is evidence that tends to show that you're not guilty. Now, the reason that's important right here is because the state attorney's office and the police department, that's the prosecutor who takes the cases from the police, they didn't do their homework. They didn't realize that there was an injunction, a restraining order against their victim, their main witness. In order for them to prove their case, they had to put this victim, that's another story, on the stand, and basically then say, okay, here's our judge, jury, everybody, here's our victim. We're putting him on the stand. We're going to take his testimony as truthful. But, oh, wait a minute. We never looked to see if it was illegal for this guy to even be near our client. Because it was. He's violating a restraining order. Not only is he violating it, but he puts it on his, he records it on his phone because he's recording our client as if she's doing something completely horrible, like beating on him, which I didn't see that in the video at all. So basically what the state attorney's office is saying, hey, here, incriminate yourself. We're okay with it because, you know what, we don't know about it. But we had an obligation. Mike and I found out about this, and it wasn't until late in the game. It was 2 nights before.
No, we found out about this part a couple of weeks, or like 2 weeks earlier is when we filed our...
We had that Sunday night conversation now, remember?
Yeah, but it was about 2 weeks before trial that we filed our notice for compulsory judicial notice.
Okay, that's what I want to... so I don't want to confuse everybody, but what we did to show that we had a document that the state really ought to take a look at, Mike, and this is the... With electronic filing nowadays, we can file something anytime we want. Sunday night at 10 o'clock, Monday morning, 2 a.m., it doesn't matter. That's an advantage to us because then we can sort of figure out, oh, we just found out about this, but technically court doesn't open up till 8:30. So we should think this through before we let the court know, before we let the state know that we have an injunction that blows up your case. Now, why wouldn't we do that immediately? Because we weren't sure. We still needed to do due diligence to make sure the document that we had was what it was supposed to be, meaning, is the state really going to put this guy on the stand to testify when all we need to do is get up and say, is this you? Sir, is this your name, your birth date? Were you served with this? Is that your signature? And then he'd have to take the Fifth Amendment and remain silent, or if he admitted it, then he's admitting a crime. So the judge blew the whistle, called a...
Let's not get there. Let's not go that far. Let's not go that far yet, because we have stuff before we get to the day of trial where that happened. I just want to kind of talk about how it affected our thought process before we get to what happened in court on the day of trial.
It affected our thought process by thinking that, you know what, we can't lose here. Either way,
So,
they're going to put him on the stand and let him incriminate himself, or we can show the video of him incriminating himself. You have two ways to do it. The case was really at that point done.
So basically, we get this document late in the game, and it opens our eyes to something that's cataclysmic to the case. It is a game changer for this case. The other thing that happened here, apart from that checkbox about the injunction being enforced and the police not verifying it, is this issue on injuries with none visible. Remember, I read you the police report, and it's very plain that the victim told the police that he was, quote, punched in the face several times with a closed fist. Okay? Now, I don't care who you are. You don't have to be Mike Tyson punching somebody in the face. If you punch somebody in the face with a closed fist multiple times, there's going to be a mark. Maybe there's going to be more than a mark, but there's certainly going to be some indicia that you were punched in the face with a closed fist several times. Even Chris Rock, who just got slapped, had a mark on his face. So imagine the closed fist, multiple punches. So that made the body worn all that much more important. And here's another spin on our case. Because remember, we've already determined the litigation objective. We've quoted a fee. We know what we're doing. But as this discovery process is rolling along, things change. These curveballs are coming at us. Now we know there was absolutely no visible injury on this guy. So now not only do we have this cop going to take the witness stand and he's going to have the answer as to why he didn't verify that injunction and why he didn't do his job and why, but we also are going to be able to take a look at, hopefully, body-worn camera, which we now know we can't get, but at least we got this report and we know we're going to get out of the cop on the witness stand. Hey, if this guy was punched in the face multiple times with a closed fist, it would beat the crap out of me because I didn't see it. There was no evidence of that other than his word. So that's another big point for us, and yet another what? Detail. If you don't look at that, if you don't focus on that and pay attention to it, right over your head, it's gone. And that's a tough thing because, again, there's a difference. If he said, look, she shoved me, that's still a battery. It's enough to sustain a conviction if you can prove it. But it's not believable. It goes to his credibility, as does the injunction, excuse me, and the issue of the real basis of this case, which became our ultimate theory and what we were going to be pushing, that this had nothing to do with domestic violence and it had everything to do with child issues, specifically timeshare. And ultimately, things would happen just about 4 or 5 days before trial that would play out to really prove that that was 100% true. But we'll get there in a minute. So what do Mark and I do? Well, we go pull those injunctions. That's the first thing we do. We pull the injunction and we see there are 3 of them. And now we become aware of his injunctions and we come aware that he had filed 2 and that they were dismissed and that hers was granted. We get all the injunctions. So what do? We file a request of the court to take what's called judicial notice of the domestic violence cases in civil court, the injunctions. This is a legal protocol that's employed where you want to not have to call a clerk of court or otherwise authenticate a document or an item or an incident which is self-authenticating under the rules, such as an existing court file in the jurisdiction where you are trying your own case. It's a no-brainer. So what it did was it put the state on notice and it put the court on notice, and that was that. The judge took judicial notice, and we move forward from that point. Now we get about, I don't know, maybe 4 or 5 days before trial. It's like the Wednesday or Thursday before trial. And our client, we're having another conversation with her, and she tells us that she just recorded a telephone call or a portion of a telephone call with the victim. Again, another violation of the restraining order, this guy being on the phone with her. But she just recorded a call where he basically told her that he will not show up for trial. And by the way, we were set for trial on a Tuesday. So it was last Tuesday. the message, the conversation he says, if you just give me time sharing with the kid, I won't show up in court. Just give me what I want and I won't show up in court. And she recorded it. Now, you may recall we did a show about a month ago on electronic eavesdropping. And we talked about how it's illegal in the state of Florida, which is a two-party consent state, to record telephone conversations or verbal conversations without the knowledge and consent of the other party. Everybody has to know and agree to being recorded. Well, there are exceptions, and one of those exceptions is if you have a order of protection in your favor, and the subject of that order of protection is violating the order by calling you or talking to you or showing up and communicating with you or doing it over the phone or over the internet or whatever, you can record that for purposes of proving the violation. So any of you who might be thinking, oh, she recorded him, that was illegal. Well, that was our first thought too. But we happen to know that there's a domestic violence or a order of protection, doesn't have to be domestic violence, any protection of order of protection, exception to the electronic eavesdropping rule. So we have this recording, and what do? I mean, as Mark just said, it's exculpatory evidence in our possession, and so we immediately tender it to the state. We send it off as what we call reciprocal discovery. As Mark said, you don't have to invoke discovery, but if you do, then you are obliged, it's called reciprocal discovery. You have to give the state just the way the state has to give you. So we give it to the state, and again, this is just a couple days before trial. And now, that was either Wednesday or Thursday. We're preparing, we're going through everything with the client again. Trial is on Tuesday, and Monday night, the state serves us with a video that was reportedly recorded by their victim on the night of the incident. Now, mind you, this is the first time we have ever heard of this, and they've had this case open for 6 months, and now all of a sudden this video appears out of nowhere. Now, forget the content of the video, because as Mark said, it certainly didn't show our client doing anything, punching this guy or committing any act of violence. It did, however, show this guy chasing our client around like a lunatic until she got in her car and drove away. We also don't know when that video was actually recorded, even though they claim and purport that it was this incident. That said, they serve us with that, and they also hit us with a litany of what are called motions in limine. These are pretrial motions that the court needs to rule on before we get a jury in the courtroom that limit both sides in terms of what they can and can't do, where they can and can't go, arguments they can or can't make, evidence that will or will not be considered. It's stuff to make the trial go smoother because they're dealt with in advance. And one of the things that the state moved in limine to prohibit us from doing was talking about that restraining order. They wanted the restraining order out, claiming that it was not relevant to whether or not our client had committed an act of domestic violence on that particular date and time. And it was also highly prejudicial to the state in that the state might, the jury might acquit the defendant only because, or in part because of that injunction, when it has no bearing on whether or not our client actually punched their victim in the face multiple times with a closed fist. So we get to court on Tuesday morning. We're ready to argue. The state's there, defense is there, defendant is there, defendant's family is there, the jury's outside of the courtroom, and we are literally going through these pretrial motions one by one until we get up to that one. Now you can take over.
Okay, just let me back up, because this is going very fast, and a lot of people out there may not be keeping up with this. But the argument that you just put forth, where the state was saying, forget about the injunction over here, forget about this, and look at the fact that the defendant may have hit or punched.
I think you just froze up, Mark. Yeah, You're there. You froze up for a second. Go ahead. I'm sorry.
Yeah, you did. I lost you. That's the point. If he had gotten up there, and if the judge had made a poor ruling and saying, you can't use it, well, then we could have used self-defense. And in putting we didn't want to put our client on the stand for other reasons here, but if we had to, we could just introduce the injunction that way by saying she was acting in self-defense. She had an injunction. The state, here's the point. The state was playing, we're playing chess, and the state was playing Candyland. Okay?
We were playing three-dimensional chess.
They did not go through their case, and the problem here is you're dealing with very inexperienced prosecutors. If any of you out there are going to be going to law school or you're in law school, the advice that I can give you that you might remember from the show is take any class. If you're going to be in the courtroom or make your living anywhere near a courtroom, take evidence and take any class associated with helping you learn how to put documents into evidence, fight documents going into any type of evidence, physical evidence, medical evidence, whatever it is. A trial has to have evidence. So if you're going to be a litigator, you've got to know the rules of evidence. You got to know them better than the other side. You have to know them as well or better than the judge, which a lot of times gone up against attorneys with a lot of experience, and they just clearly know evidence better than everybody else in the courtroom, and they have a distinct advantage. We had an advantage here. We have two attorneys with experience working on a very remedial, what appeared to be a very simple battery case, but what turned out to be what could be a lawsuit for our client. I don't really know how those work. I stay in my own lane, but she really shouldn't have been arrested. If we're doing an autopsy here, Mike, if you're opening up the case, she really should never, and if anybody at home picked this up, she shouldn't have been arrested. He should have been arrested because, as Mike has told you, an injunction enables somebody to do what? With that piece of paper, what can they do, Mike?
And have you arrested if you violate.
Because you've gone to court in front of a Miami-Dade County judge and you have had a hearing or attempted to have a hearing and you put forth evidence that has not been disputed and the judge is saying, yeah, you know what? You are entitled to a restraining order to keep that person 500 yards away from you, 1,000 yards, whatever it is. Well, their victim was about a half a foot away from our client, the defendant. And I'm still kind of, I'm listening to them, still thinking like, because when you're in the heat of this and you're matching their move with our move and then their move, and this is all going on, but you set it up for the judge to have to make rulings. We really didn't know. I didn't have experience with this judge. Mike had a little bit more experience, but it became very aware. I became very aware, as we both did, very quickly, that this judge had a grip on evidence. She was an experienced litigator. She did criminal defense work in Broward. She was on her game. So she smelled this out. And I'll turn it back over to Mike to let you know what her ruling was here. But it was only one. The only ruling that a judge has to do several things here. The judge has to make it fair for the state, the government. Judge has to make it fair for our client, the defendant. But the judge also has to look out for the person, the witness who's sitting on the stand and not be asleep at the switch. And what do I mean by that? This guy would have got up there. Oh, she hit me. She did this and that. But the judge knows ahead of time that if he got up there and testified that he was even near her on that day, that she was going to have to declare a mistrial, most likely, and turn him over to the state for an investigation.
Prosecution.
To investigate. But here's the point. So you're a prosecutor here. They took their sweet time. They went out in the hallway and everything. The bottom line was this. If you're a prosecutor and this is presented in front of you, you know what? You cut that cord as fast as you can and you move along to the next case. They kind of, we were nice about it, but we didn't have to be. They took their sweet time with that. That wasn't even a close call. They would have presented a guy on the stand that they would have had to turn around and recommend arrest. Yeah. So
what happens as we're arguing this motion now, Mark brings up a couple of really good points. This was a misdemeanor case. Misdemeanor cases are handled in county court. They are not felonies. Felonies are handled in circuit court. Prosecutors, there are career prosecutors. There are people who prosecute for decades and even more. and excellent prosecutors. And there are some young prosecutors who are very sharp and real good. But overall, it's like anything else. It's a learning curve, and it takes time and it takes practice. You don't go into your courtroom as an expert on day one, or even year one, or even year three, or even year 30. We're still learning. Things still happen, and we have to research and regroup and figure out. But unfortunately, the younger the state attorney, the less experience, and sadly, these days, the less training, at least locally here. I mean, I'm not speaking for anywhere else, but my primary practice is here in Dade County, and so I see it all the time. When we bring something to a prosecutor and say, you need to look at this, and their immediate knee-jerk gut reaction is, screw you, screw that, now we're withdrawing the plea offer. I mean, that's really the way that they react, childishly and foolishly. Not everybody. I don't want to blanket them all, but as a general operating principle, that's what we've come to expect. And that's clearly what happened here. They didn't care about the restraining order. I don't even think they read the restraining order. They were absolutely married to the A form in this case. Remember, they had no 911 call. They had no body-worn camera. They had no handwritten statements. They had no injuries. You got to look at all of this and question whether or not this happened the way that the victim said it happened. Plus, they've got motive, because where did it occur? It occurred, if it did occur, it occurred at baby mama number one's house by baby mama number two against the common baby dada. So you got to know that there's some kind of a, game going on here that's intricate and involves more than just a violation of criminal law. There's more to it, but they didn't explore it. They didn't care. They didn't take the time. They didn't show the effort or the initiative. Instead, they just doubled down and said, we're going forward, and figured we're just going to get it excluded. Well, that didn't happen. As Mark said, our judge was very sharp, and she understood the realities and the practicalities and the possibilities. So she said to these two young prosecutors, listen, the restraining order is relevant to this case, but more importantly, it's relevant to your victim. And I don't think that you guys have really thought through what's going to happen if you put your victim on the witness stand. Because either he's going to, if he testifies the way that he has consistently testified, he's either going to incriminate himself, in which case I'm going to have to appoint the public defender's office to represent him, and I need a PD here in this courtroom on standby because I'm now on notice, and you guys might need to take him into custody and prosecute him. Or, if he's smart, he's going to take the witness stand and invoke the fifth, in which case he's not going to testify to anything and he won't incriminate himself. So, have you really thought this through? And of course, these two looked at each other and said, yeah, no problem, whatever. And the judge said, no, I want a supervisor here in the courtroom. You get a supervisor from your office. I need to make sure before we go any further, because I don't want to lose this jury panel. There are other cases. There are other defendants who deserve a fair shot at justice today. And you guys need to think about what you want to do in this case with somebody who knows a little bit more than you. And so that's exactly what happened. The prosecutor supervisor came into the courtroom, and as Mark said, the three of them powwowed outside for 15, 20 minutes, whatever, looking at this, looking at that. And ultimately, they came back in the courtroom and they dismissed the case. So, why did that happen? Were we ready? Mark and I were there, ready to pick a jury and ready to go forward on that case and ready to achieve substantial justice for our client in the form of an acquittal. We love hearing those words, not guilty. Now, we can never promise a client a not guilty verdict or anything else. We can promise that we'll give them 110%. And in this case, Mark and I 110% said, we're getting an acquittal in this case. We are comfortable. There is enough missing evidence, enough things that should be there that are not there, that are inexplicably. You think a jury's going to buy, oh, yeah, well, there was a 911 call, but you know what? We didn't think it was important enough to preserve it, so it just got destroyed. And yeah, there was body worn, but, there was a malfunction, so sorry, jury, you guys don't get to see it or hear it for yourselves. But don't worry about any of that. Focus on the shiny object right here. No, that's called reasonable doubt. Reasonable doubt comes from three things. It comes from the evidence, it comes from conflicts in the evidence, and it comes from the lack of evidence. So we had a clear lack of evidence in this case. Then we go to conflicts. We got a guy who claims to be punched in the face multiple times with a closed fist, yet there is absolutely no physical evidence to substantiate that he was ever touched by anybody. And then finally, we've got motive. Because the truth is, we've got a guy who for 4 years has had no rights to his daughter, has no time sharing, has no ability to see this kid, unless our client is willing to allow it. So he's basically subject to her whims because he didn't go to court and enforce his own rights. So there's motive here. Because if he gets our client arrested and convicted, maybe even incarcerated, where's the kid going? You know? We look at all of this, and to Mark and I, we're saying this case is an absolute winner. And so we were there to win. But we were there to win on a jury trial. And sure enough, motions in limine got so screwed up in this case, the state screwed the pooch so badly that the judge basically had to open their eyes to the fact that they needed to dismiss this case, which to their credit they did. Although I can't give them a whole lot of credit because the truth is they don't deserve it. That's the reality. So do we have a happy client? Yes, we do have a happy client. She was acquitted. Well, she wasn't acquitted. The case was null pros. It was dismissed. So I guess you can't technically call that an acquittal, although it's the same end result. But the reality is she hampered our ability. Had she told us about that injunction, or had she authorized us to engage our investigator to do a deep dive, he would have found it. But none of those things happened. So to some extent, our client handicapped us. And that's a problem. And that's a great pro tip for you guys. If you ever hire a lawyer, and it's not limited to criminal litigation, I'm sure the same applies civilly. You got to be transparent with your lawyer because you will handicap your attorney if you don't tell him or her everything that the lawyer needs to know. Thoughts?
Yeah, just a couple of things that, when I prepare a case, in my mind, I'm always thinking of what I'm going to say in my closing argument. And for selfish reasons, I really wanted to try this case because it was very simple in its facts, but it was very complex in the evidence that needed to be introduced or kept out for whatever reason. Now, I've been a prosecutor like those young prosecutors that were at the table that, were all ready to go, but didn't either have the experience or the work ethic to work through each thing. And even if they did, they should have seen that they had two lawyers on the other side of the courtroom with their client dressed for church, ready, chomping at the bit, ready to go. Now, when I was a young prosecutor, if I saw that, then I would immediately send a red flag saying something's wrong with my case, that they can't wait to try this. They didn't pick up on these signals. Therefore, the judge, politely, because she has to work with the prosecutors in her courtroom on a day-to-day basis, politely said, take a look at this and then come back into the courtroom and tell me you're going to get rid of it because this is going to be a disaster. And she didn't want to deal with it. And quite honestly, it should have never got there. And the more that I sit here and think about this, listening, the more I think that we should refer this client to an attorney that will look at this, do the autopsy that we're doing, and see if there's liability. Because they arrested her, okay? They took her to the police department. They sat her down in an interview room. They read her Miranda rights. She denied being there because we didn't really know if she was there or not anyways. I mean, there was no date time stamp on the video,
and the video was never given to the police.
Right. So my point is that she's, she did what she was supposed to do. In
fact, let me, I don't mean to interrupt you, but think about this for a second. When we read that DV Supple report, which was done by the officer who first responded, so that's in real time of the incident, right? They have it in that report that there was ring video, but it didn't capture it. Yet they didn't say anything about a video that this guy made with his cell phone.
Yeah, because he was using that for leverage later on to bribe her or whatever with that. No, Mike, it was again.
Extort, I think, is the word you're looking for.
What?
Extort, I think, is the word you're looking for.
Yeah, but really, she was handcuffed, taken to jail. Had to go through the process that Mike explained earlier. She had to come out of pocket for lawyers. She had to deal with house arrest. The more I think about this, the more we should refer her to an attorney that will look at liability, because the North Miami Police Department is a horrible arrest. This thing it was a disaster.
Now they screwed the pooch with this one. And
mean,
I will say, apart from the police, really, I have a much bigger problem with the prosecutor than I do with the police. And here's why.
I have problems with both.
Right, I have a problem with both, but my problem is bigger with the state attorney. And here, only for this reason. I'm not excusing law enforcement at all because they committed an utter fail. They did an utter fail.
The prosecutor. They brought that.
Yeah, but here's the problem. The prosecutor is a lawyer, and that is a check valve. The prosecutor's job is to ferret out mistakes and bad arrests and cases that should not go forward. That's part of their mandate as being ministers of justice. And you know this better than me because you worked under Janet Reno. And Janet Reno's philosophy when she ran the Dade County State Attorney's Office was, as a prosecutor in my office, you do not blindly prosecute. If you have a problem with a case, you dismiss it. You dump that turd. And if your supervisor will not sign off on it, come to me directly. My door is always open to you. Janet Reno, you could say what you want about that woman, but she ran a very, very, very well-structured ethical ship. She demanded ethics of her prosecutors, and she trained the living shit out of them and made herself available. That office is not run that way these days, not even remotely.
Well, she used to recruit purposely students like me from out of state to come into Miami-Dade, and I was always kind of like, why aren't there more local law students coming in here to work? And one of the senior prosecutors told me because she doesn't want any trace of corruption whatsoever by bringing in local people. And I thought that's kind of, but that was coming out of the 80s. That's kind of a big firewall to have there. Okay. Right. She was paranoid.
My point being is that her
first speech the first day is you don't take a case that you're not comfortable. If you're not comfortable with it, you take it to your supervisor. If you don't get the answer that you're comfortable with, exactly what you said, you come up to my office, you sit outside the door, and I'll get with you. And
I'll go a step further than that, because I was a private defense attorney at the time when she was still there for many years, and her door was open to us. If we had a problem with a prosecutor in her office, she wanted defense attorneys to communicate that. She wanted to know if there were issues in her office. She did not turn a blind eye and play games with things like that. This type of a case would not have gone forward under Janet Reno. That's my personal opinion.
Yeah. Well, I mean, my supervisor for domestic violence would have never let this. I mean, they, quite frankly, would have told the police officers to
lawyer up.
That's
lawyer
bad.
Up, guys.
This is a horrible, horrible case. Now, listen, there's just a lot of problems right now with government jobs. Okay, but that's the problem, is that you can make excuses for the state attorney's office and say they're young and they're not trained well, but to the expense of what? Someone else's liberty? Someone else's life? I mean, say what you want. It may not seem like a big deal, but this woman getting pulled off the street, arrested, handcuffed, taken to jail, bonded out, house arrest, fitted, can't go there, can't go here for months on months, then has to go to the courthouse thinking, I'm going to trial. Holy cow. She was scared. All right, she's scared. All that so that this ex-husband or whatever this guy was he was instilling this fear in her the whole time. If you don't give up your child to do this, I'm coming to court to testify. Well, you know what?
I mean, could you believe the temerity of this guy to actually? And so we get this recording and we tender it to the state. I mean, there's no question it's him. It's his voice. There's no question he announces that he won't appear in court on Tuesday, which was something the state actually argued. I mean, I'm sitting there in disbelief when the state attorneys are
try the case.
The state attorneys are telling the judge, "Well, judge, we don't even know if that's him, and we don't know when it was said, and we don't know this." And the judge is like, "Excuse me."
I'll ask him when he's on the stand.
No. The judge said,
"No, that's
I'm sorry, but the judge said this is the first time this case has actually been set for trial, and I special set it on a Tuesday. So don't tell me that if this guy says on that tape I won't show up in court on Tuesday, which he clearly says, he's not talking about showing up in court today." I mean, that's the judge having to tell the state. That's how obstinate these.
Okay. Yeah, but Mike, we're sitting there saying, okay, you don't want to. You think it's not on that date? Put him on the stand and let me ask him. But there you go, chess. You put him on the stand. I'm not going to get him with I'll get him with the recording too. I'm going to get him with the restraining order. We boxed them in again. They were playing chutes and ladders there, and we already moved the pieces so that they could. We knew what they were going to do. We knew what they were going to do because, like you said, it's always if you decide you're going to be aggressive in your defense, your file's going to stick out among the others. You're going to make them work, and they're going to take it personally, which a lot of them do. They take this personally, and that taking it personally creates emotion. And I'm very good at getting under the skin of other lawyers, and that gives me an advantage right off the bat. They're not thinking clearly because it's now about me and not about the client or their witness.
Well, I think what we've shown you guys, at least I hope what we've shown you is a little bit
of still on?
Yeah, we're still on. The insight that we are going through as lawyers. What are we thinking? How are we processing? How are we manipulating and putting pieces together? How are we strategizing? How are we coming up with ideas and concepts? And all the same time being aware that these curveballs can come at us at any point in time, as they did in this case, including literally the night before trial was to start, when we received the video and the motions in limine from the state. And so, here we are, and we have to kind of be prepared to expect the unexpected. So I guess what I'm trying to say to you guys is, to the folks, if you find yourself in a position where you need to hire a lawyer, hire one that thinks outside of the box, that understands how to play the game, and go through it with them, and be honest and complete. There's nothing you can tell us that we're going to repeat. Well, almost nothing you're going to tell us it's going to repeat to anyone else. And if there's something that you're going to tell us that we're going to think is going to be a problem, we're going to cut you off and say, hang on, stop right there. Don't admit to this because I don't need to know it. I don't want to know it. You're going to create a problem. So overall, pro tips: hire smart, trust your lawyers, be honest, be open, be diligent. And when you're right, you're right. Listen to your attorneys, because in this case, our client could have taken a plea at any point in time, and she was very scared and ready to do it. Now, we didn't talk her out of anything. Her family talked her out of it, to be perfectly honest, because her family was not as emotionally unstable and vested as she was, and they were able to explain to her, look, your lawyers are telling you this is a good trial, and they believe they're going to beat this case, and we believe in them. You should believe in them too. And therein lies the lesson. Anything else you want to throw in before we sign off?
You get what you pay for. I'm out. I'll talk to you later, Mike. Thanks for
thank you,
for
Mark.
having me.
Lawyer Mark with a C on TikTok, folks. Thank you very much for being on episode 39 of At Your Service with Haber and Martinez, albeit in this case with Morris. Thank you for watching. We appreciate your time, and we look forward to seeing you next week. Take care, y'all. Thanks again.